Good afternoon. Welcome, and thank you for joining us again today from your bubbles for a discussion on running a business moving into level 3 and beyond. I hope you and your families are all safe and well at this time. A special welcome back today to those attendees that have been tuning into our webinars over the past few weeks. Today's live stream webinar is the 7th in a series of webinars run by Godfreys Law, and it's the second occasion where Dorian Crighton from PKF Goldsmith Fox is joining us. So for those of you who may not know me, my name is McDonald and I am one of the business owners at Godfreys Law. I've been with the firm for 20 years and involved in the running and management of the business for the last 12 or so years. So I've got a good appreciation of what it's like to be a business owner, having been through earthquakes and other challenging times over that period. I'm also an employment lawyer, and I also practice in the field of commercial law. I'm going to be your host today for the panel discussion. In today's webinar, our panelists are going to talk about the various important elements and issues that you need to be considering as we all move into level 3 next week. I'm sure that you all find something of value here today, and once again, thanks for joining. So today we're going to mix it up a little and change it from last week, and I'm going to get each of today's panelists to introduce themselves, and we'll start with you. Thanks, Dorian.
Yeah, thanks, Brad. It's always hard to introduce yourself, actually, I find, because it's always try and be humble. But yeah, I am a chartered accountant and involved in all aspects of both business development and accounting-related services. I guess the key to my relationship is doing the two sides of the business, supporting and growing businesses. So it's just providing more than down-to-earth accounting and tax advice, just trying to assist in all levels of business from strategic planning to delivery. I've a large amount of experience in construction and associated trades, and a special interest in developing successful businesses through planning, implementing efficient processes and measuring against KPIs or key performance indicators. I've owned a number of small businesses in my time outside of accountancy, which I think provides gives me a unique ability to provide some input. I'm also currently chair of PKF New Zealand, a New Zealand-wide group of firms. So thanks, Brad.
Great, thank you, Dorian. Andy, over to you. Thank you.
Thank you, Brad. Good afternoon to everybody watching and listening to this. For those that have never met me before or don't know of me, I am an employment and general lawyer with Godfreys. I've been there 4.5 years now. Prior to that, I was with other firms in Christchurch, and prior to that, I was in Wellington doing a variety of things, including working in the courts up for 23 years, and made redundant in 1996 as Registrar of the Court of Appeal at that time, and turned my head to what can I do, and formed my own business, which I ran whilst I picked off a law degree and came to the law somewhat belatedly. However, I've got good life skills and certainly have lived the commercial life, both as an employee, employer, and as a business owner. So I too have the sort of side skills that Dorian referred to. I enjoy doing the employment side of things with Godfreys. I'm also in the litigation team. I do general debt recovery, company assistance, taxation negotiation when companies are in a little bit of bother with the revenue, and other general work that a general practitioner generally does in a law firm. So that about sums me up, I think. Brad, and back to you.
Great, thank you very much, Andy. That was a really good summary of your background and experience, and it's very, very broad and so unique skill set that you bring to the table. Thank you. James, over to you, please.
Hello, everybody. For those who don't know me, my name is James Hobcraft. I've recently joined Godfreys actually just before the lockdown started. Like Andy, I picked off my law degree over a longer period of time while I was in business. I've owned a number of small businesses in the last 20 years, and some of those have come up against the wall. So I'm very familiar with the sorts of financial struggles and difficulties you might be facing as employers in particular, and business owners during this period of time. So like Andy and Brad, I enjoy employment law, and my strengths lie with commercial law matters. So all of us on the panel today bring that unique skill set to the table where we can see both sides of most arguments and can give you some proper and useful practical advice, as well as the technical advice that is required from time to time. I'll hand back to you, Brad.
Fantastic. Thank you very much, James. That's great. Rightio. So before we jump into things today and all the meat and the sandwich you're all looking forward to hearing, I'll just do the fun bit, the lawyer's disclaimer. So I'm just going to rattle through that and hopefully not send you all to sleep. But it is important just to go through this. So we're offering today's live stream webinar to you as a free service to give you some guidance and support at this time of great uncertainty. It's an opportunity for you to ask questions of us today relating to business issues you are facing at present. If you're watching, you can pose a question through the Q&A function on Zoom, and our panel will do its best to answer that for you today. However, it's important to understand that when you listen to the answers that are being given, those answers will be given to a specific question, and the answer is often given in the absence of all the background facts and documentation that might relate to your problem. You can see there that can create some difficulties potentially. Also today, some panellists may be talking about proposed legislation, and of course, where they talk about proposed legislation, they can only talk to guidelines that have been made public and things they understand currently. In many cases, we're operating on similar information as the general public, but of course overlaying that with our specialist skills to interpret and understand what it might all mean, which is a $64 million question. So when you listen today, you shouldn't rely on the answers given by the panel to support a legal position you might wish to adopt. Rather, any statements or answers are intended as guidance to assist your general understanding of the landscape as we understand it here and now today. And things have changed and will continue to change rapidly, no doubt. In closing, you should always take detailed accounting or legal advice about your specific situation before you act or commit to any particular course of action, just to make sure you've got your I's dotted and your T's crossed. Rightio, that's enough from me. I'm going to hand it over to Dorian so we can all hear from him and his thoughts and insights about moving to level 3 and beyond. Thanks, Dorian.
Yeah, thanks, Brad. So realistically, I thought today I'd take my time to talk about not only what you need to do in level 3, but just a bit of a reflection on business in a general sphere and a space, and how you can actually navigate over the next 2 to 3 months, really, as well, because we're all hoping that level 3 is only for a couple of weeks. So fingers crossed. So I guess when I'm looking at any business, I sort of put my accounting hat on, and I put my my business development hat on. And so I guess one of the things that I'm seeing with my accounting hat is as a requirement to communicate with the Inland Revenue. We've got 7th of May coming up, and so there's that dreaded provisional tax. If you do nothing, then the Inland Revenue take a dim view of that. But if you actually ring them, look, they've got plenty of people on the call centres. They're really being accepting of arrangements. If you're like some of our clients that have most successful clients got in touch with us, we've had the ability to look at their financial statements and analyse their provisional tax anyway, so bring it into line. So I guess that's one of the key things. One thing I'd like to say is that if you're looking for support from the government outside of the wage relief, the loan scheme has stalled. and from what I'm seeing within the PKF network and through my discussions wider through the accounting profession. So if you're relying on that from support from the bank beyond the temporary overdraft, which they tended to pass out, don't rely on that. So don't have that as part of your plan, but certainly don't rely on that in as far as cash flow goes. I do see some encouraging signs that Grant Robertson and the SME specific minister are getting a little irate with the banks. The banks are trying to be, on one hand, be good lenders and not put people in a worse position, but not really understanding the drive of what the government's fiscal package is looking for. So I think that would be one of the things to watch out for is don't sort of think, oh, well, I can always just go to the bank and they'll give me some money, it's great. If you can get it, the interest rate's about 1%. So it's good money if you can get it. Just be aware there's a wee bit of work that goes through with that. So beyond that, I guess it's last week we talked about communication a lot. I know Andy, James and Brad all talked about communication in the different spheres. Keep that up. I've just said that the bankers might not be quite able to support you, but keep talking to your bank, your solicitor, and your accountant and your suppliers, landlords, all those people. Just keep that communication up, especially when you get to this rush of potentially opening up in level 3. So I guess keep the communication up. Now, I sort of noted down there's 4 things to do. So obviously communication. Next thing would be to look back at level 4 and reflect on what technology you've put in place, what avenues of sales that you put in place, what were other things that you did during level 4 that actually pushed your business forward or helped set you up. Because at the end of the day, don't go, oh, that was level 4, let's forget about it. I know some clients that have started working with FaceTime and videoing their clients and their various products and being able to ship it out. So that opens up geographical spread of your market. So that's one thing. You know, don't just sort of think of level 4 in isolation out the back. You know, just really reflect on what did you do and what were the successes that you got in your business. There may be none, and that's fine. But don't, even if it was just, I really enjoyed reading a business book. Who would have thought? You know, but really take on board something like that. So I guess, so communicate, look back at level 4, and in level 3, hopefully you listened last week and we're already preparing for level 3. It's coming. So I guess it's extending out what you're doing now, but making sure that it goes through to level 2 and beyond. And so I'm sort of linking in level 3 with level 2, because whatever you're doing now, make sure that it's compatible with moving forward. I was talking to one of my clients, and it was a very, hey, look, I'm really going to be able to do this in level 3, and that's fine. And it was great, but it couldn't actually progress any further. It was a bit of a sort of a roadblock. So spending a lot of time and energy looking at a 2-week window, which is important, but don't forget to make sure that business is always on a continuum, and you really want to be able to, anything that you're implementing now, make sure that it flows through. So, so those are the 4 sort of things: communicate, look back, look at where you are, and look forward. So those are sort of some general ideas of what you can do in your business. What I'd like to do is, I can never remember this thing, so I've got it up here on the screen. I'll have to read it out. And the guy called Chris Cachola, the fact that one of the earliest lessons I learned in business was that balance sheets and income statements are fiction. Only cash flow is reality. And as an accountant, the first part of that hurts. because it's all about balance sheets and income statements. We all know that. That's all that matters. But in reality, we all know that cash flow is king. So what I'd like you to do now, I can't see you, so I'm trusting you, is that I'm wanting you, we're going to go over 7 key causes of poor cash flow, just quickly. We're going to run them through. And so your homework is to write down next to each of those points, one thing that you're going to do over the next week or coming period to improve the cash flow in your business. Okay, so this is trying to give you something practical to be able to do and some practical advice. So the first thing is your accounts receivable process. Obviously, it's great having money owed to you, but if you have poor accounts receivable processes, it will stifle your cash flow. There are many strategies to minimise debtor days, including tightening terms of trade, making sure that there's proper payment discounts, all those sorts of things, streamlining your billing service. So think of one thing that you can do to make sure your accounts receivable process is a bit tighter. The second thing is the opposite, is your accounts payable process. Now you can say, well, how can I improve my cash flow with that? It's reviewing suppliers' terms. You may be able to potentially get better terms of trade. Making sure that you implement a budget is key, and streamlining your payments process to maximise any prompt payment discounts. And we all know the IRD like their late payment penalty, so making sure that you're not hitting any of those. So make sure that don't neglect this area of your cash flow. Make sure you look at that. The third thing is inventory process. Look, if you sell time like I do, my inventory is the team's time, or whether it's stock. Just make sure you're not carrying XX stock. I've already had one client who's gone mad buying up for getting back into business, and so he's put himself 2-3 months behind in cash flow already. So be aware of your cash flow involved in inventory and or your lockup. Make sure it gets billed. If you're selling time, make sure that you're not having wastage with your stock. So that's the third thing. If you're selling time or product, make sure you put something in place to make sure that doesn't suck up cash. The fourth thing is a great one: inappropriate debt and capital structure. God, that sounds like it's been written by an accountant. Basically what that means is big overdraft, no term debt, or to be blunt, owners ripping too much cash out of a business. So really as a business owner in these current times, really reflect on where you're going with how much you're drawing out of the business. I'm taking less now. Do I have to? Probably not, but I just feel it's good practice to keep as much cash in the business as you can. The fifth area of poor cash flow is overheads. Your overheads really should be reviewed, and hopefully you've taken some time over here. We're getting some rent relief here, but just make sure that as you're getting into business, take the opportunity just to go through your overheads. Make sure that you're getting the right bang for your buck. The sixth thing is gross profit margins too low. So that's basically where you're buying something and your markup's not there. Now, often people can be price takers, or the market won't be there. But when you look at the way Uber's been attacked, because businesses just can't, they're just looking at ways of keeping the hospitality businesses keeping their margins up. So think about how your gross margin, what your gross margin is, and how you can increase it. Decreasing rework and wastage, reducing stock shrinkage, productivity, all these things really help there. So, and the last one, sales too low. Well, I know that's a bit staggering, that if you don't have the sales, surely your cash flow will follow. But look, it's really an opportunity to sit down and review what market segment you're in. Obviously, well, not obviously, I have some motelia clients, and so sales are, strangely enough, a bit low at the moment. So how are we working to actually increase those sales? What market can we attract into our business? So I've rattled through them because I'm mindful of time, but make sure that you look after your accounts receivable process, accounts payable, inventory process, look at what's getting drawn out of the business by debt, overheads, margin, sales. At the end of the webinar today, my name will be up with an email. If you want, I can send you just a one page of those things down so you can revisit it. More than happy to. And further, email me. We've got a webinar at 11 o'clock tomorrow for the PKF network that's going to talk about a lot of the government and tax specific structuring. So that involves the wage subsidy, the loss carry forward thing, a bit more about the business loan. So if you're interested in getting that 7 key causes of poor cash flow, or you want that involved in the webinar, do email me. It'll be at the end of the thing. Whew, that's me, Brad, and I'll pass back to you.
Awesome. Thanks, Dorian. There was, look, there's some really good material, and thank you very much. And I know in terms of those 7 key things you've just outlined, myself and my business partner have run through most of those, but it's good. For me, you know, I've even been in, you know, business owner for 12 odd years or so, you know, wouldn't say I know everything, and it's good to get those sorts of lessons reaffirmed, because to me, in times like these, with respect to what you've just said, in many respects, it's about stripping it back to the basics and you know, doing those well and taking a good hard look at those sort of key elements. So that was fantastic. And I think the second thing that I wanted to pick up on from what you've just said is you've got to know where you've come from to know where you're heading, and I think you encapsulated that very neatly, because I think, you know, it would be a real shame for any business owner not to reflect on the lessons they've learned from level 4 and how they might be able to take those forward, adapt and or evolve those moving into level 3 and beyond. So yes, some really good stuff. Thank you, Dorian. Great. Rightio. Andy, I'll hand over to you. Thank you.
Thank you, Brad. Thank you, Dorian. Just from Dorian's talk there, we're all looking positive. Everything is looking like a good move into level 2. Just in the blink of an eye, this can be undone and we could be back at level 4. You know, so let's take up Dorian's cry there to remember what's gone down in level 4, because it could come again. Now, I don't want to be a doom merchant like that, but flowing on from that, how are you as business owners now facing what's still going to be a fairly lean time, even in level 3, and possibly a slow start in level 2? Are your own personal butts covered? You might be company directors. You've all signed personal guarantees somewhere along the line, possibly for rent or stock or bank overdrafts. What are your personal assets? Are they safely tucked away in a family trust? Is your family trust actually operating the way you want it to be operating? Is a family trust the right vehicle for protecting your particular assets or your particular interests at this time and moving forward into the future? It might be time just to sit and reflect on that, and if you need a trust, come and see the trust team at our lovely firm. They'll be happy to walk through the pros and cons of trusts with you and look at other possible structures to protect your particular needs. There's, just as an aside, there was a client of the company that had a well-meaning other firm set up a trust for him. He thought everything was nice and safe and tucked away years ago, only to find out that his house wasn't included in the trust because it had been set up by an accounting firm who, of course, can't convey property into the appropriate structure. So, lo and behold, oh, woe is me, my house is now at risk. So we've managed to get that sorted out and matters regularised. So it's things like that that perhaps a timely review of your trust and other asset protection strategy may be timely. Also, heading into or back into the lead up to full-on business, but under different circumstances, we've got to have a nod to health and safety. It, like employment law, hasn't changed. The requirements under the Health and Safety at Work Act haven't gone to sleep because we're in lockdown. All people working remotely should have been had their workspace checked, made sure that there were a suitable work environment with no obvious dangers. And like normal times, if there ever is going to be such a thing again, that's a two-pronged attack, because it's not only the business owner or the PCBU, as we've probably all become accustomed to knowing what that means, but the workers also have that obligation. That too is possibly going to lead into some issues going back into level 3 and further beyond, where we've still got the vulnerable workers who shouldn't be at level 3 going back into workspaces in any event, according to those regulations. And if required to go back in, the employer may be in some difficulty and in breach of that Health and Safety at Work Act. So that too needs to be a matter that is taken into account when determining what and who comes back into work, what and who can do what when you get back to work. So it's something that you will need to think about carefully, because, as I said earlier, like the Employment Relations Act, it hasn't gone to sleep while all this has gone on. I am sure that in the employment arena, there's a few employers that are going to have a few nasty surprises coming to meet them, when people can get to see people like us and get appropriate advice. And if things have gone pear-shaped, don't want to compromise it by adding insult to injury, and excuse the pun, but by breaching health and safety requirements. We should all be well aware of what our requirements are now. We've all been in business. This is not a new act. It's been around since Adam was a cowboy, it seems, but it's not. It's just been tarted up and forced upon us in a big way and in a meaningful way, and it is an act that the government actually enforces quite rigorously. So employers, be aware, just be aware that those obligations are still live and kicking and can come and kick. So I think that's all I want to say on that particular subject, Brad, so I'll hand back to you.
Great, thank you very much, Andy. Just quickly, I think it's a really important and key message that you've just conveyed there. And the reason I say that is I've spoken with a number of business owners recently in the last week, many different fields, and the rush to get back to level 3 and what that might look like for their business and their business operation, including the office or the warehouse or wherever it may be, and what staff are going back, if any at all. But for those that are going back, I've posed the question, well, have you turned your mind to how you can safely do this and your obligations as a PCBU, person controlling business undertaking, and what steps are you putting in place to control risk at level 3? So what contract tracing are you putting in? Do you have a site plan for visitors? And obviously people are not allowed to come into the office, etc. under level 3 to my understanding. What is your cleaning regime going to be? What does the safe social distancing within your workplace look like? Those sorts of things. Do you have any other thoughts or comments there, Andy, about practical tips?
Those are the obvious ones, obviously, Brad. The requirements under level 3 under the COVID requirements will determine to some extent how your business should be operating, and I say that because I'm well aware of businesses where social distancing isn't occurring in the mad rush just to get things going again and keep things going. So it's something that can, as I alluded to earlier, something that can come back and bite in an employment way, if not in the health and safety way. There's a multitude of factors that you need to consider rather than rushing headlong into getting those doors open and people through them, because at level 3 you're not meant to be having too many coming through the door at all, and everything is meant to be contactless, and that includes your staff.
Yeah, thanks, Andy. That's good. And look, from what I've seen, there's quite a lot of good resource online from the government on the COVID-19 govt.nz website around these sorts of considerations. So yeah, look, it's a really important thing that business owners shouldn't overlook in their planning to go into level 3 and I'd suggest level 2 and beyond. So yeah, no, that's great. Thank you very much, Andy.
Thank you.
Rightio, we'll hand over to you, James, and some updates from you, no doubt.
Thanks, Brad. Before I get into legal updates, I just want to talk a little bit as a business owner to anybody out there who is a business owner watching. I don't ever remember a time quite like this where I've had such a long period to reflect and think about my business. And so as Andy and Dorian and Brad have said, you should take this opportunity to really evaluate things. I know personally, my business has very much been a contact business where I've had the reliance on a premises and interaction with people and very little focus on online selling. So I've been turning my mind to the possibilities of setting up online stores and things, and I've discovered there are a lot of good templates. So I encourage you to use this time not to fret, but to try and be creative and to evaluate things as they are for you. Talking a little bit more on the lease side of things, carrying on from last week, a couple of things have cropped up in discussion with clients during the week, which I'd like to share with you. One of them is the idea of a frustrated contract. Some people have said, look, I've got a deed of lease for this tenancy that I'm occupying for my shop, but I cannot access it, I cannot use it. The landlord still wants me to pay the rent, and these are typically people who don't have the benefit of the rent abatement clause that was discussed last week. So one option that occurs to them is, can I argue that what I have is a frustrated contract? Now, it has been established in New Zealand for a number of years now that a lease can become a frustrated contract. But something people seem to have a miscomprehension about is the idea of a temporarily frustrated contract. And there is no temporary frustration as far as I'm aware. So if you were going to run an argument that your lease contract was frustrated and therefore it was at an end because the landlord could not provide you with the access, then you need to keep in mind that if you're successful in that argument, that will end the contract and you will lose the tenancy. So something to think about. There are many other factors there as well, such as the remainder of the lease. One thing that has been determined is that when working out the remainder of the lease to see if it has long to go or short time to go, which is going to be very influential in the decision about whether the lockdown has created a level of frustration, is that renewal terms are to be counted. So if you've got a lease which only has a few months to run on the current term, but then 2 further periods of renewal, well, it may well be that it wouldn't reach the level of being frustrated by a lockdown that only operates for a few weeks or a couple of months. So that's that matter. Now, the second matter I want to talk about is the situation that a few people are finding themselves in where they do have the ADLS lease with the clause 27.15, which creates the rent abatement, and that is where the landlord is not giving them a rental adjustment. So people are approaching their landlords and saying, well, 27.5 applies, let's negotiate a rent discount, and the landlord is saying, well, no, we're not giving you a rent discount, or we're going to let you defer the rent. We won't collect it off you now, but at the end of the day, you need to pay it. And people are finding themselves in a position where they're worried about losing their tenancy and are feeling pushed into having to pay the rent. So we can help you there if you're in that situation. A lawyer's letter will perhaps be a little more persuasive than one from your email. The second thing we can do is we can help to put the landlord on notice that you disagree with their proposal and that you have a point of view that you'd like to put forward. And then as a last insurance, there has been talk that there's going to be a bill introduced. And I had a look earlier today and I see there's no bill there yet, which is going to change the notice periods for termination of a lease due to non-payment, which is going to operate with effect from 10 days after, I think it is the 25th of March. But basically from early April until now, the normal 10 working day notice to end a lease for non-payment of rent will be extended. I think it's to 30 days. So that pretty much concludes my updates for the week, and I'll hand back to you, Brad.
Right, thank you very much, James. That's useful, and it'll be interesting to see when that bill hits, because that will significantly elongate the current timeframes under the lease. So that'll be interesting to see how that goes. James, I wonder, do you have any thought or comment with the rush back to level 3, how that might impact tenants who have, say, negotiated an abatement for April during level 4, whether that might put them, for example, if they go back into their office or warehouse in a weaker position with their landlords to argue some sort of abatement, say, for May or beyond, even if they only have a few members of their team in the building, for example. Any thoughts?
Yes, I think there is a potential problem there. I alluded to this last week in the idea that during level 4, where there is no access, almost certainly clause 27.5 will apply, and the landlord will be obliged to provide a fair reduction in rent. However, that argument's not so clear-cut in level 3, because then you have arguments where, well, you do have access, so the clause doesn't apply, and then the tenant's argument will be, well, I have limited access, hence I cannot fully conduct my business, and it becomes very messy. But certainly I would imagine that a fair abatement, a fair reduction of rent and OPEX during level 4 would be more than level 3 if you are accessing and utilising the premises in level 3. So by rushing back, if level 3 is indeed only a 2-week time frame, you may actually prejudice your arguments, you may receive less relief, and you need to weigh that up in the context of getting into your business and getting it open and trading again. Trading will be frustrating and difficult. There will be limitations, some that we won't have imagined yet, and will only be seen operationally when you're in there trying to operate.
Right, thank you, James. And look, that last point I think is really pertinent. That what lies beneath will not be known until you wade in some respects. So some things, there are some unknowns at the moment. So that will be interesting to see. Yeah, thanks, James. Rightio. So moving forward, I'm just going to talk today before we hand over to address any questions that come through from today's attendees, and we've already had some that have come in before the live stream webinar, so thank you for those, and we'll start with those and deal with any others that might fly through. But look, I'm just going to pick up and have a chat today about employment law, specifically restructuring and redundancy. Sadly, it's probably a question of thought that's entered many business owners' minds over the level 4 period and moving forward, no doubt, in terms of what landscape are we going into, what's it going to look like, how is my business going to survive. So I think it'd be disingenuous to suggest it hasn't been on people's minds, and that's why I want to talk about it today. Firstly, I just want to explain a little bit of the interplay between the two terms, redundancy and restructure. Often I see those terms used interchangeably, and to my mind, one flows from the other. And what I mean by that is typically a redundancy, which is where you have an employee or employees surplus to requirements. That typically flows as a result of a restructure process. So sometimes the word restructure is used to mean redundancy, but there is a fine but important distinction there that I think is worthwhile teasing out for you. With respect to any proposed restructure and any redundancies that may flow from that, these require a really careful and considered approach. I say careful and considered approach because there are many, many traps for the unwary. And even those who do a pretty reasonable job can fall foul of one pretty big substantive or procedural mistake, and that can be very, very expensive in the Employment Relations Authority and or court. I think with respect to restructure and redundancy, as I've seen a little bit with the wage subsidy application of that and some of the dubious practices that have gone on there, sadly, there can be a danger of a knee-jerk response in these times to say, well, we need to restructure and make people redundant. It's not to say it's not the case, but you need to undertake a very important analysis before you reach that conclusion. And if you've done that, then I'm going to talk today a little bit about how that may all look for you as a bit of a steer. I want to pick up on something that Andy talked on before in his presentation, which is it's really key to remember employment law obligations have not been changed in New Zealand. So all the usual rules that apply still apply in this circumstance, albeit extraordinary. So it's really critical you get clear on your obligations before you launch into any process if you're looking to restructure and thereby as a result of that process make staff redundant. At all times you must adhere, and you would have heard us if you've joined us on previous webinars, this term, you must at all times adhere to a good faith process. And what that looks like will be similar but importantly different for each organisation depending on the individual circumstances. I know that's a frustrating catchphrase or caveat, but it's quite simply true because every scenario is different. So what does a good faith process look like, or what could it look like? So this list I'm going to give you is not exhaustive, so don't take it as such. But a good faith process for me includes the following sorts of elements. Firstly, a careful and detailed assessment of your business's position, its financial health and the staffing needs of the business moving forward. In order to do that, in my view, you're going to, or in order to form a clear and concise view on that, you're going to need to take advice from your accountant and any other professional business advisors you regularly engage with to get really clear on the health of your business and what it might be able to suffer moving forward and what its needs are vis-a-vis staff. Next, you need a really clear identification of why staff are surplus to the requirements of the business, and your first steps are going to help to inform that. And you need a really, what us employment lawyers call a solid substantive justification. So a little bit of legalese, but boiling that down, it means you're going to need a solid business case. It just can't be paper thin. That's not going to fly. Because using a process improperly or for improper means, which is known, and you may have heard this before, as a camouflage redundancy, to get rid of, say, underperforming or irksome employees is not going to fly. It will stand out all day long. So will a poorly conceived business case and process resulting. Next, a good faith process would include consultation with your staff over any proposals, and curiously, this is a step that's often overlooked by employers, the need to consult, and I'm not sure why, because the Employment Relations Act has been around for 20 odd years now, and that requirement's always been in there. So you've got to consult and you've got to follow, and this is another critical element that many employers often get wrong and skip or just simply miss, I think. You've got to follow any process that has been mandated in your employees' employment agreements. Oftentimes, employment agreements will have a process that must be followed in this sort of scenario, restructure and redundancy. If you don't follow those and you make a meal of it and ignore that, then you're going to get slammed. You're going to have a grievance on your hands. So that's why it's really important to spend time and effort at the front end of this whole thing if you're seriously contemplating this sort of process. And you need to take detailed legal and accounting advice, and I simply can't stress that enough. It's not because I want to line my pockets because, you know, I can dress something up that may be of use. It's that I know that the likes of myself and Dorian can provide real value to you in this scenario in an effort to try and protect you and your business from expensive grievance claims. The way I like to put it is we're the ambulance at the top of the cliff, not the poor guys in the boat who are picking up the pieces at the bottom. So once you've designed a process in good faith, typically these processes share some similar characteristics, including, and this is in a practical sense, a formal written notification of your proposal to your staff with the relevant information you're relying on informing your view that a restructure and or a redundancy is required for your business. You need a clear outline of the process that's going to be followed so people know where they stand and what's going to happen. You need to also outline the timelines for each step in terms of deadlines where feedback or consultation needs to be given by, etc., and when decisions will ultimately be made. You also need to let your employees know, and this is critical, that they have the right to take legal advice and have a representative or support person present at any meetings that might occur, whether that's in person or virtually. It is arguable, and I know there's been some discussion around this, and it might be a question on your mind, that the sort of process could be condensed in these extraordinary times. Again, I would sound a note of caution, as potentially consultation processes may be compressed in this current climate, but again, it is very much case-by-case basis, noting that employment law obligations haven't ceased. So your processes are going to need to contain most, if not all, of the elements I'm talking to. You'll need to, as I've said before, consult with each potentially affected employee and give them the right and the opportunity, importantly, to provide feedback on your proposal, which you must seriously consider in good faith without having a closed mind or a fixed view that this person is gone. You need to develop and then disseminate to your staff a selection criteria if there's more than one employee that might be in the firing line for redundancy. And that selection criteria is basically a matrix of skills and requirements and how you're going to select people to be retained and potentially made redundant. That criteria needs to be disclosed and open for consultation as part of that process so employees can feedback on it as to the fairness or otherwise. You also need to have a strong consideration of any alternatives that might be to redundancies, and I know that sounds a bit counterintuitive perhaps in these times, but it's a legal requirement. You're going to need to look at whether you can redeploy an employee to another role you may have, or whether there's an opportunity for them to still be involved in the business, albeit on a part-time basis. You're also going to need to outline any supports that are available for employees and recommend you offer these, such as access to free and confidential counselling services, because this will be stressful for these people. I'll come back to that in my closing. So once a thorough and considered consultation process is complete, you'll then need to make some decisions, taking into account in good faith all the feedback you've got as part of your process, as to what steps, if any, you might ultimately take. Once you've formed up some decisions, they need to be formally communicated to your employees, including end dates for employment and whether they are required to work out their notice period, for example. If you make anyone redundant, you should consider offering them access to free counselling support or job seeker assistance and training, such as drafting of CVs or help getting back into the workforce, especially for older employees who've been in one role for a long time, for example. You could also consider making an ex gratia payment in good faith over and above any redundancy notice payment or compensation. And they can be different things, so be careful there again, check your agreements, in order to soften the impact on anyone that you make redundant. Finally, there's the closing off the relationship and making sure you adhere to all the payments that need to be made, such as holiday pay and and the like when this is all done. So the above is merely a rough guide of the source considerations and steps involved. It is not exhaustive. It's a case-by-case situation, so proceed with real care. I want to close by saying utmost importance of dealing with your employees in good faith. And I know we keep banging on about it, but it's the underlying thread that holds this all together. If you do that, then you're a long way home. That requires you to be open and transparent, and we've talked about how you do that through a fair and open consultation process where you're on the level. You need to be responsive and communicative to employee communications, concerns and questions, and not just ignore them and bury your head in the sand or give them trite responses. And finally, you need to act compassionately and treat people with dignity and respect. The reason I say that in closing, the compassion and dignity and respect, is that we're all human beings, and often I find these things can in extraordinary times go by the wayside. You need to remember, and I'm not trying to preach at you, but you need to remember that any decisions you make could severely impact someone's livelihood and that of their family. So it's not a guilt trip, it's just a reality. Redundancy is usually a devastating blow for most people, and it has been rated as one of the most stressful life events anyone can experience, right up there with death of a loved one and a divorce. So in closing, I cannot understate the importance of taking debt over by strongly enough. The costs of getting this wrong and being on the end of an unjustified dismissal claim can run into the tens of thousands of dollars. So proceed with care, proceed with caution, and always in good faith. Rightio. So that's me done. Thanks for listening. Andy, you've got a comment there?
Yep, Brad, I'd just like to add a wee bit to what you said there. And I think even though we are in a sort of a yo-yo economy at the moment, very, very dangerous to rush into redundancies, because it's a position that is redundant. It is not a person. The person merely fulfills the position. So if you're making a digger driver redundant because you don't have the work, and within 2 weeks, all of a sudden you need to hire another digger driver, that redundant person, or that person who has been laid off, may very well come back and say that was a false redundancy. So you need to take very careful advice and have good cash flow projections going forward before committing to such an act, because it's not something that dies once the employee skips out down the road with or without an ex gratia payment, but it's that employee sitting there harbouring a feeling of unjustness, and will be watching with eagle eyes, or his former workmates will still be in touch with him and saying, well, guess what, you know, somebody sitting in your digger now. You know, it's just something to bear in mind, guys. It's tempting to do, but think carefully.
Thank you, Andy. Yeah, look, that's a really good clarification point you've raised there, to be very mindful of that, you know, our future, the unknowns, and, you know, what that might look like, because you could end up in hot water pretty quick. So really good point. Right, what I'm going to do now is head over to the Q&A session or component of this webinar. So look, I'm just going to launch straight into that because I'm conscious of time. So I'm going to start with a question here that's come in via email that I'm just looking at, and it may well be, I think this is one for you, Dorian. My question relates to the government's guaranteed loan scheme and the very difficult rules and criteria around it. I've been in contact with my bank several times, and they continue to use the term guaranteeing group. I've never heard that term and I'm still trying to get my head around it. I queried our commercial manager, and his response was as follows. I guess the easiest way to think about it is that if you are a director of a business and you have applied for the lending, then you are unable to apply for further lending under any other entity that you are a director of. So in this this person's query, it sounds like their group has a number of operating entities with different shareholders and directors, and this explanation seems very restrictive. How do I explain to one set of shareholders and directors that they are unable to apply for the loan because I've already applied under another company name within the group? Well, Dorian, any thoughts?
Oh, it's actually one for the lawyers, that one, isn't it? And certainly, as far as tax grouping and everything, it's quite a different scenario. So I think I will spiral pass it back to perhaps Andy or yourself, because really what I think the question's about is how do you act as a director, where if you're over here as a director, you're causing an effect over here, and how do you act in the best faith of each company? Because obviously, if you're taking a loan over here, which may cause cash flow stress over here, where does your directors look? You know, how do you justify being a good director here but a bad director here, and what have you? So yeah, so I'd actually be interested to hear your opinions on this, because I have actually been asked this question before, and I got to a bit of a roadblock as far as where I could provide technical advice on this.
Thanks, Dorian. Andy, do you have any views or ideas on that one?
I haven't turned my mind to it, or been required to turn my mind to it, Brad, until now, but the first thing that leaps to my mind is this is a separate legal, the company's a separate legal entity, and they're standalone. So perhaps the bank is trying to lift the corporate veil. Don't know what you think about that, Brad.
Yeah, look, as you've said, it's not something I've considered before. It's an interesting one, and I agree with your view there that the companies are standalone legal entities. It's just a scenario they happen to be part of a group of companies, and they're obviously trying to group them into the same box. So it seems like a very inequitable outcome. But I guess the bank is looking at it across the whole group position rather than a standalone position. James, do you have any thoughts on this?
Yeah, just listening to that, I think that the appropriate method of grouping companies is by shareholder interests, in much the same way that the Inland Revenue would group companies. There are several situations where people are merely professional directors. They have no ownership interest in a company. They're simply fulfilling a role as an officer, a director of the company, and it would be wrong, in my view, for the bank to consider that a grouping basis. So it might be worth revisiting it. If there's a common shareholding, well, then that may make it more complex.
Yeah, and James, that's sort of where I got to with it as well, is that it seems strange that you'd attack the director level. I mean, I've got a few directorships that I operate professionally, and I'd be horrified to find if one of them caused an issue for another. And I think in this particular case, if I'm not mistaken, we've got one bank providing this with other members of the group. That's my PA. In the background, the other members of the group have different banks. So it'd be great to see a bank crossing another one. So, but yeah, it's an interesting one.
I suppose a lot may turn on that particular group's cross-securitisation arrangements with the bank. That's something we don't know, and I don't think we should be trying to give unqualified advice on whatever the particular issue is here without having a full grasp of the background facts.
Oh, go on, Andy.
No.
Yeah, look, I think it's
my firm's insurer would not like it.
It's clearly a scenario where, you know, it's going to require a bit more work, but I think, you know, there's a good comment there, and you know, look, I just find that a very curious stance. Just a first logic basis, the bank would take that type of approach, but it's going to require a bit more work for everyone, I think. So there's some opening thoughts there at the very least. So look, we've got a few more questions in fairness to everyone. We'll get on. Rightio. So this question here has come through on the email. Maybe I've jumped too quick. I did a deal with my landlord early on that April's rent for my building could be paid off later in the year, an amount of $2,000 over a period of time. I realise now I should have pushed a bit harder and tried to get some of the rent cut. Is it too late to try this, or should I just try anyway? Any thoughts there?
Golden rule, don't ask, don't get.
I agree with Andy there. It's always worth a try, but it will turn a lot on the nature of the agreement you've reached. If in reaching this agreement on the deferment, you've actually set out terms such as this is a full agreement in relation to the period during level 4, those sorts of agreements would make it very hard to go back. But if it's an informal kind of arrangement, then sure, why not?
Right, thank you. Rightio, here's one that may be up your Strauser, Dorian. Is it worth getting the loan to get business continuity plan done? It feels like that's so far out in the future, but I'm struggling just to keep going the next few weeks, and borrowing money to get a distant plan done seems wrong.
So can you repeat the question, Brad? Was it the borrowing money to get a plan done?
Yeah, correct. This person's using the term business continuity plan done to get a loan to get that done.
Okay, so yeah, so I guess what they're talking about is the fact that the banks will often have a few criteria. They'll want cash flow. They'll want to know what you've done to mitigate your expenses. They'll want to know what borrowings that you haven't levered. They'll take anything except credit card. So if you've got a home loan that's basically got some fat in it, they'll say, why aren't you using that? And then they'll take a range of guarantees. Further to that, they will often ask for, and I've seen a bank that's got yellow in their logo ask for a full plan developed. And some of it, and especially when you look at some of the level of borrowings, is quite draconian. And even then, I think the rider at the bottom is often, we hope that this meets the criteria and we'll be able to process the loan, progress the loan. So there's not even a guarantee at the bottom of that. My advice would be, if you do need to go down that path, that you look up the regional partners on their website, and there's providers that will provide business continuity plans through that regional partners, and will be funded as part of the $25 million government program to help businesses through this. We're PKF Goldsmith Fox, we are registered with them, and we are providing those programs, and they are supported. So I wouldn't be borrowing money. I'd be looking through that partners program to make sure that if that's part of your requirements, that you can get government assistance with that.
Further to that, Dorian, Christchurch NZ.org, I think it is, council-run wing of local government. The Christchurch NZ offers a grant of $1,000, I think, for professional advice to business owners in circumstances like this. If that's a grant rather than a loan, why would you be borrowing? That's also Dorian's other suggestion there. There's two avenues open.
Right. Thank you, Andy. Thank you, Dorian. Rightio. Next question here, the wage subsidy question. So they're still coming through. We put the wage subsidy in a separate bank account as we thought we had to, but the trading is now so tight we might have to dip into it and we'll replace that money once things get better. Is this okay? Andy's nodding a firm no.
That's my view, no.
About it. When that money was distributed, what happened was, I believe, an institutional constructive trust, so there's a legal term for everybody. You signed a declaration in which you agreed to use that money for the purpose of wages only. So to take it and use it for other operational expenses would really be a breach of that trust. So you should avoid that if possible.
Thanks, James.
I have seen instances in some companies where the subsidy has been applied for and received, paid out in full to all the employees who are then made redundant. So I think that was also flagged by somebody from MB as being an acceptable practice that would be unlikely to be attacked as part of the liquidation process. So I think that makes it clear that we just simply can't take that money and apply it for any other use other than wages. Also, just on that note, the MSD has been recovering and doing audits, and there's some millions of dollars now being recovered from some of the scallywag stuff that's been going on from people misusing this. So be careful, don't dip into it. That would be my advice.
Right, cheers, Andy. Thank you. Just a question come through. Can I hire someone now that has been made redundant, and I presume it's from the same business, and apply for the wage subsidy for them?
So there's been specific advice released on that, and the short answer is no. Okay, Brad, you're on silent, Brad.
Thanks, Dave. Well done. Sorry, there's been a clarification come in on that person is from a different business, so it wasn't from the same business. Okay.
Yes, I was about to say the actual act of rehiring somebody you had previously made redundant so as to be able to apply for the subsidy for them was encouraged. And I think that contemplated a scenario where the bad trading in early March might have led you to make somebody redundant, and then the wage subsidy solution was announced, and then people were saying, well, look, I've laid this person off, can I get the subsidy back for them? And so the solution was, yes, re-engage them and get the subsidy for them that way. But it's a very narrow and limited application.
Yeah, and I think the general idea was to keep people in work whilst the business was suffering. It would be hard to argue that your business is suffering if you're hiring more people. So yeah, and that's the rationale behind what the clarification's about. Yeah.
Great, thanks, Dorian. Thanks, James. Look, that appears to be it for the questions for today's webinar. So I think it's a good time to start to wrap things up. So we've just run over slightly an hour today. So look. Thanks once again for taking the time out of your day to join us this afternoon for this live stream webinar. I hope that you found some value from this presentation and learned some new things and taken away some tools. Don't forget Dorian's offer to email him if you'd like that list of 7 actions you can take with your business, and whether you'd like to attend the webinar they're running tomorrow at 11. And we'll put some details up shortly so you can get in contact. If you'd like to get in contact with any of us post today's webinar, you'll have our contact details up shortly. And if you've got any requests for particular topics that are of interest to you, then please drop me an email at my email address with any suggestions that you might have. Moving ahead, we'll continue to host ongoing webinars, so look out for another one this time next week. And in closing, I would like to thank all of today's panelists for their time and their engagement and expertise in this webinar. And in closing, to all of you who have been watching, Be kind, stay safe and well, and we will get through this together. And thank you very much, and take care, and I hope you have a safe and enjoyable long weekend in your bubbles. So many thanks to our panellists, and now I'm going to put up the contact details for all the team today. So just bear with me while I do that. Rightio. There we go. So I'll leave that up for a moment for you to scribble down the detail, and we look forward to seeing you again in the near future. So thank you all. Take good care.